All right, Paula, and I'm going to hide this for you. And here comes Paula. Come on in.
Okay. That is an introduction made for TV. Thank you, Katie.
I tried.
Yes. Good morning, everyone. Thank you for joining us. We really do appreciate your attendance, and we're hoping that you can gain some knowledge out of the 2024 legal update. Again, kind of the framework for today's presentation, there are a lot of slides, and these slides will be provided to you, correct, Katie?
Yes.
Via email that you registered with. So you will have the slide presentation, which is a great reference, especially for our condominium listeners today with respect to SERS and milestone changes from the May 2023 legislation, the glitch bill. Let's get started. Really quick about myself. I don't like to take too much time, but I like to let you know who you're listening to today. Paula Mera. I am from Kansas City and took the Missouri bar, Kansas bar, wisely relocated to Florida and took the Florida bar. I have been practicing in Florida for over 21 years. My career started at a large law firm in Boca Raton, representing hundreds of associations, where I focused my law on condominium association, country club law, which is always interesting and fun, homeowners association, and co-op. Also some litigation background with respect to foreclosures, enforcement of governing documents. As Katie mentioned, we are a full service law firm, and we pride ourselves on the fact that our clients do not, and they're not referred out for any of their community association items, including just day-to-day governance, corporate representation, litigation. Our bankruptcy component here is strong. Steve Brayton is a colleague of mine. He has over 26 years experience and a really strong bankruptcy background, which is the unfortunate circumstance where associations have that collection or foreclosure that moves into bankruptcy. So we're happy to represent you all in that as well. Our collection and foreclosure paralegals have actually been with Mr. Rosenbaum, our managing shareholder, for over 32 or 33 years each. So it's an amazing group that we have in our collections and foreclosures. Mr. Rosenbaum has practiced for over 43 years. We have a strong litigation team. However, for our community association clients, we like to keep you out of that hallway and in, again, to the day-to-day governance. We also have Stephanie Galloway, who's just joined the firm, and she is in our association department. Lily and Laura also in our litigation team, but we also have a lot of insurance issues that come our way, and we can assist you with that as well. So let's get started. I am going to move through some of these slides fairly quickly, as soon as Katie assists me on moving those through. So let's talk about the HOA legislative changes. We're going to talk about this first. A lot of our slide presentation is for condo, but I think it's helpful, even if you are an HOA listener, to understand those changes with respect to our condominiums. But House Bill 919, Homeowners Association Bill of Rights, effective October 1st, 2023. This has not been talked about much. So let's get into the different changes that were implemented just recently, this last month, to 720. 720 is our governing statute for our homeowners associations. The requirements for board meetings now includes the requirement of identification of all agenda items, except if you have an emergency. So that is a change that is now, your notice for your board meetings will include your agenda. Most likely you are already including your agenda, but just note now that the statute has changed and you are required to include your agenda. Maintenance of official records. The association will maintain a current roster of all members. You're required to keep track of the designated mailing address of your members. Keep in mind that this statute change will allow owners to opt in to certain information being disclosed or to opt out. So that is a different change, again, for 720, for a current roster required to be kept for all your members. That becomes important when an owner wants to make an official records request for that roster so the owner can disseminate information. So keep in mind that from a management perspective, you'll want to keep your roster, understand what an owner can opt into, what they can opt out of. Also, with respect to email addresses, if we have owners who have opted into receiving notice via electronic transmission instead of paper snail mail, those email addresses will be an official record. So once they have submitted that written notice that they prefer to receive notices via email, their email will be an official record. And so if somebody wants to inspect the official records, they will have access to those owners' emails. If the member revokes their consent to receive notice by email, the email fax number must be removed from the record. So this is all, again, now codified into 720. Deposits. This is important because oftentimes associations will collect a deposit from a member, such as construction deposit for your ARC. They have to be kept separate. They cannot be mixed with any other association funds. So as the treasurer, you want to make sure that you have implemented a process or procedure to confirm that those deposits that the association collects are not mixed with an association other funds, other bank accounts. And once that project is complete, let's use, for example, the construction project, and an owner has to submit $1,000 deposit. It's going to be kept separate. And when I ask for my deposit back, it will be returned to me in 30 days. If a member requests an accounting of their deposited funds, that accounting has to be provided in 7 days. So again, these are HOA owners' rights. We're going to move through some of these slides, as I mentioned, because this is actually not new legislation. We're talking about fiduciary duty here. We're not taking kickbacks. That has been in the statute with respect to 617 for over a decade. So Katie's going to remove these slides for us. And if you attend this again because you thought it was so great today, you will not be seeing these slides. Grounds for immediate removal of a director or officer. Of course, if there's a forgery of a ballot envelope or voting certificate used in an election, this is new statute with respect to making that a crime. Theft or embezzlement involving the association's funds. That's nothing new. That has always been a crime. Grounds for immediate removal of a director or officer. Destruction or refusal to allow inspection or copying of the official records of an HOA within the specific time frame. Such an act is also considered tampering with physical evidence, as stated in a separate section, section 918 of Florida statutes, and obstruction of justice. This particular provision, again, amended into October 1st of this year. I'm not a huge fan of this. A lot of times that there's going to be accusations with respect to the destruction of or refusal to allow inspection. At the end of the day, the association needs to maintain their official records to where one director or one officer is not in control of those official records to either destroy them or disallow inspection of records.
Paula, really quickly, before
Yes.
you move forward on the agenda, are they only able then to discuss the items listed on the agenda?
That's a great question.
Yeah.
The question is, for the agendas, now that 720 requires your agenda to be included on your notice of meetings, is the board only allowed to discuss those agenda items? Typically, what I always recommend is if you have an agenda, it's been posted and your members understand that that is going to be the business of that board meeting. And so moving off or away from those agenda items is, it disadvantages those members who did not attend that may have thought you were talking only about the agenda items, but you have ventured into some other area of business. So my recommendation is always to stick to the agenda items, but I understand that sometimes we have new business that may not be an agenda item, or we have a lot of associations that have like a town hall style at the end, hopefully prior to the adjournment of the meeting, where there's an open-ended discussion on different issues that may not be on the agenda. So the answer is other items can be discussed at meetings. Specifically with respect to Robert's rules, it should be specific only to the agenda items. And that also keeps for a cleaner meeting, depending on how many meetings you have per year. All of those different factors can be considered. So legally, you're not required to stick just to the agenda items. But again, in my opinion, it makes the meetings more disciplined with respect to their structure. And again, owners who don't attend because they don't anticipate that the board will be discussing some other type of item or matter, they don't have notice of that. So it's fluid. You can discuss other items that aren't on your agenda. Typically, your agenda will include new business as an open item that may be discussed by motion. Again, we are moving through the conflict of interest and disclosures. This is part of our board certification course. This is nothing new. And we don't have anything new with respect to the conflict of interest, which exists for officers and directors. Fines, this did change for 720, and it's something in an area to pay attention to, especially if you are a community that levies fines. Keep in mind, your community association, HOA, and condo and co-op, you can only levy fines if you have an independent committee of at least 3 individuals who are unrelated to board members, managers. In that setting, when we do have the fining committee, after the association board of directors levies the fine, the committee, pursuant to statute, is then required to impose or not impose the fine. For the 720 changes, the board will adopt the fine. The notice is sent to the member's designated mailing address, and then the owner has the ability and right to attend the 14 days noticed hearing committee. The notice will include details, and this is where the changes come in to 720. It's going to include details of the alleged violation and the specific action required to rectify the violation. They have the right to attend the hearing through telephonic means or other electronic means. This used to come up from time to time because typically our committees, our fining committees, will have the fining committee notice to the owner at a specific location, a physical location. Now we can allow that owner to attend via telephone or Zoom, etc. After the hearing, the committee must provide written notice of its findings to the parcel owner at their designated mailing or email address. This may become very important if you intend to, once that fine is imposed, let's say it's $1,000, you intend to collect that fine, you will want to make sure you are checking all of the boxes with respect to what the statute requires, or you could create an issue with the collection of that fine after it's imposed. If it applies, the notice is also going to give to any occupant, licensee, or invitee of the parcel owner. It's going to be in the circumstance where at the clubhouse of the association, the young person's guest comes and does something that has then resulted in a violation and a fine. If it applies to that, the notice is going to go to that invitee of the parcel owner. Typically, our recommendation is the parcel owner is responsible for their guests or invitees, and so the fine should go directly to that parcel owner for enforcement. The notice is going to include the approved or rejected fines or suspensions and instructions on how the parcel owner or any individuals can rectify that particular violation. So essentially, the changes to 720 for fining has more specific requirements that you need to meet. So if you're going through that and you do have an active fining committee, make sure that you reference back to 720-305 with the new changes. Fraudulent voting activities for 720. The creation of the new section 720.3065, provisions relating to fraudulent voting activities in association elections. The takeaway point here for my HOA listeners is usually your HOA bylaws or articles of incorporation, they may or may not have very specific provisions with respect to how to conduct your elections. And so one of the areas of improvement by virtue of amendment we always recommend is amending your bylaws to create a voting and election procedure that looks a lot like the Condo Act. And that is the notice requirement, 2 notices, the requirement of any interested candidates to send back a notice of intent to be a candidate by a certain date, and then voting by secret mail-in ballot. It's very clean, and there are no questions as to whether or not your election was conducted properly or not. I can tell you from 2020 forward, we have had an uptick of probably about 150% with election disputes for our HOA clients. So keep that in mind. You're able to amend those bylaws to provide a more cleaner and direct and specific voting process. These fraudulent voting activities, it's willfully or falsely swearing or affirming in connection with voting activities. I like the second one, perpetrating, attempting to perpetrate, or aiding in the fraud relating to casting a vote, trying to change a ballot, or attempting to change other members' ballot, or prevent them from voting as they intended. Menacing, threatening, or using bribes or any form of correction directly or indirectly to influence, deceive, or deter a member during the voting process. The manner in which this comes up is typically ballot harvesting or individuals going door to door to solicit votes through the HOA voting process. And again, what I recommend is moving your voting process to look more like a condo voting election procedure. Number 5 would be offering or promising anything of value to another member with the intention of quote unquote buying their vote or corruptly influencing their vote. Keep in mind, this does not apply to food served at election rallies or meetings. And using or threatening to use direct or indirect force, violence, intimidation, or any form of coercion or intimidation to compel a member to vote. Why we had to codify that in the statute is curious to me, considering that would be a criminal act anyway. With respect to, again, voting for HOAs, review your bylaws, review them with your legal counsel, and determine whether or not it's in your best interest to amend to have specific voting procedures that may or may not serve to avoid these types of issues coming up in your HOA elections.
Paula, so in condo land,
Mhm.
can the association documents be more restrictive than the statute?
So for our condominium associations, you will follow specifically and only the requirements of 718. You cannot amend into your documents a lesser restriction or provision with respect to your voting procedures or a more specific or more stringent requirement. It is specific to 718 that you're going to follow for your voting procedures. And again, 718, for those of you that don't know, it's a very specific voting procedure. And in addition to 718, we have the Florida Administrative Code, which governs primarily condominiums and co-ops with respect to their voting and budgets, et cetera, that have very specific requirements with respect to how the condo or co-op election is to be held. Katie did not mention that she is a state certified election monitor. So when she attends elections for our clients or even non-clients that may retain her through the state, it is a very specific process, but it's, again, nothing more, nothing less. You're going to follow the statute and the Florida Administrative Code specifically. House Bill 437, this was effective July 1st. This was an interesting change in the law that came through, I believe, through the glitch bill session. Installation, display, and storage of items, regardless of any restriction or covenant or bylaws, unless prohibited by law or ordinance, an association may not restrict a parcel owner or their tenants from installing or storing any items on a parcel that is not visible from the parcel's frontage or adjacent parcel. This will include artificial turf, boats, flags, and your camper or recreational vehicle. That's 723-045. However, I do believe that this particular statute could be challenged as unconstitutional. If you don't have Kaufman language, we're not going to go down that rabbit hole today. At the end of the day, I do think it's helpful for associations because it does, in a sense, enforce the ability to have our associations. If you are storing something that is in violation of your covenants, most of the time it's an argument as whether it's visible or not. Here, if it's visible, it's also in violation of statute in addition to your covenants. So that might be helpful for some associations. Flags, takeaway point on this is this was expanded to provide for a first responder flag, law enforcement, correctional officers, 911, nurses, urban search and rescue. We can hang and have those on the flagpole as well. 720 is very specific with respect to the flagpole and the height of the flagpole. Again, it was limited to United States flag, state of Florida flag, and then the flag representing Army, Navy, Air Force, Marine, Space Force, Coast Guard. This has been expanded to include additional flags. Flags come up and flags are problems, not necessarily strictly with respect to what we know we can and cannot put, but a lot of times individuals want to hang different flags that would not conform to the statute. Contact your attorney when those types of things happen because they're typically political flags and you want to make sure that you're on the right side of the law with respect to any type of claims that may come from the owner wanting to hang a specific flag.
Paula, I think this is an appropriate place to ask this question. With the upcoming election season, will political signs, can you prohibit them in HOAs?
So for homeowners associations, for signs overall, you want to make sure that your declaration mentioned, I did not say rules and regulations, I said your declaration prohibits signs. If your declaration prohibits signs, your rules and regulations can take that a step further and be specific about additional rules to prohibit signs. If your declaration does not prohibit signs, then you're going to have an issue with respect to the political signs being placed in someone's yard, in someone's window, or I like this creative play that I saw a couple of years ago where the individual was told to cease and desist, putting political signs in his yard. So he put them in his window, told to cease and desist because it still acted as a sign outward to the view of the yard or exterior of the lot. And then the individual, this was good. Nobody should take this. I hope nobody takes this away as a good idea. Got one of the visors on your front windshield that had the political name that he was supporting. So, and then he parked his truck facing outward in his driveway. I thought that was pretty creative. So 1, 2, 3 steps. At the end of the day, you want to make sure that your declaration has a strong sign prohibition. If it does not, you will not be prohibiting those signs. Condo and co-op legislation. Senate Bill 154, it is referred to as a glitch bill. Glitch meaning that when the legislation was passed in 2022 with respect to the Surfside tragedy, there was many provisions in that legislation that was confusing, shouldn't have applied, or overall just didn't make sense. This was described as the glitch bill, but most attorneys I know and engineers, it fixed some things and created confusion with other things. So let's go through those changes. And again, this is for our condos and co-ops. The mandatory structural inspections, that term, and we refer to that as the milestone inspection. The original bill and even this glitch bill changes the times and the dates for which your association will be required to obtain a milestone inspection. In addition to statute, I think one of the main takeaway points that sneaks up on individual condo boards is your local jurisdiction will have additional provisions, most likely, especially if you're on the coast, with respect to your milestone inspection and when they want that inspection completed. Most of my clients have already received a notice from their local jurisdiction as to when that building inspector wants that inspection to be conducted and then sent to your jurisdiction. So keep that in mind. The milestone inspection is intended to be a structural inspection of the building. It's 2 phases. It includes the primary structural members and elements of the building by a visual inspection. The inspection must be conducted by an architect or an engineer, and the purpose of the inspection is to assess the life safety and the adequacy of the building structural components. We're essentially walking through our condominium building as a licensed architect or engineer and visually inspecting that building for different sites and issues that will lead either the engineer or architect to determine whether the phase 2 milestone needs to be completed. A team of professionals may provide a milestone inspection service with the architect or engineer serving as the registered design professional in charge. And that work, that inspection needs to be signed and sealed by that qualified team member. Again, that visual inspection, we are looking for substantial structural deterioration, pardon me. If you have the picture on the top, that would obviously be a structural issue. I believe that's actually one of the components that was probably taken during a milestone inspection phase 2, where you're doing destructive testing. So the phase 1 is going to be that visual inspection for your engineer or architect to determine if a phase 2 milestone is required. Again, the deadlines, the glitch bill changed a lot of the deadlines, and those deadlines are specific with respect to the certificate of occupancy for your condo or co-op. And if you have a building which has reached 30 years of age from the date of CO, which are a lot of our buildings, if not most, by December 31st, then you will be required to have that milestone inspection. That is your deadline. Those milestone inspections are going to be every 10 years thereafter. Again, we're talking about 30 years of age and then measuring that from July 1st. It's going to be performed by December 31st, 2024. So that's most of probably our listeners today. If a building reaches 30 years of age, again, this particular glitch bill rolled those dates forward another year to 2025. Proximity to saltwater. The original legislation based the proximity to saltwater on the coastline, based upon the coastal construction line. The coastal construction line is an invisible line that is drawn around the perimeter of our peninsula, but it does not take into consideration areas like Miami, the Biscayne Bay. It does not take into consideration areas like Tampa Bay, where your salt water obviously goes in further and affects beyond that 3 miles. It has been replaced with respect to that particular proximity to saltwater. So you may have an earlier milestone inspection requirement based upon your proximity to saltwater. This glitch bill clarified that with respect to some of those buildings in those areas. The local enforcement agency may grant an extension for the milestone inspection deadline if you can demonstrate good cause. Granting of the extension may be based upon and should be based upon the fact that you have a contract or a proposal from an engineer or architect firm that shows that you are in line for your milestone inspection, but they just can't get to you yet. Because one of the issues with this overall legislation from 2022 is there are absolutely not enough architects or engineers to perform these milestone inspections for all of our condominium associations in Florida. So the glitch bill intends to provide some extension authority for local law enforcement agencies. You will have to show good cause, and that good cause, the first step is making sure that you have retained and you are in line to receive your milestone inspection. And you can show your local jurisdiction that you have at least taken that step. Don't show up to your local jurisdiction and not be able to demonstrate good cause for why an extension should be granted to your condo association.
Paula, just really quickly on the deadline, is there any chance that there's going to be a rollback on the date or any pushback on the deadlines? People are having trouble getting engineers now, even in 2024.
Right. So I left my crystal ball at home today, but it's a good question. And we hear that question often. It's actually probably the most frequent question that we hear with respect to these requirements. I believe that is why the slide I just talked about, that's why they allow the local jurisdiction to have some discretion here with respect to showing good cause. In my experience thus far, most of our clients have at the minimum a proposal and contract for their milestone inspection and a date in the future that they know they will be put on that engineer or architect's schedule. So that's at the minimum really where you should be. To the question directly, I don't know the answer to that. I could see that perhaps it might do additional roll forwards with respect to the date requirements. However, if that doesn't happen, and it may not happen just because they now have deferred to a local jurisdiction level to offer those hardship exceptions.
And Paula, most associations adopt their budgets way earlier in 2024 than December 31st. So if they adopt the 2025 budget in, let's say, October of 2024, does it have to include those fully funded, the fully funded items, or can they adopt that budget in 2025 for 2026?
So let's get there because we're not there yet. So that particular question basically was about the CSRS adoption of budget and reserves. So we're going to get there. The framework of this for today, just so you all know, we're going to cover the milestone inspection, then we're going to move to CSRS, then we're going to move to some additional new legislation that affects our condos and HOAs. So the milestone inspection, again, this slide presentation will be sent to you. And I mentioned that again because these slides are very wordy, but they do offer a great resource for you to refer back to. So the local enforcement agency is going to accept an inspection report that was performed before July 1st of 2022. So I have clients, for example, that have their milestone inspection or their CSRS that was completed previously. This particular glitch bill allows those particular reports, if they were done, the law enforcement local enforcement agency, rather, your local jurisdiction may accept one of those reports as an inspection report. Even if a previous inspection was accepted, you have to still fulfill the requirements if it was prepared prior to July 1st, 2022. I think this is a little bit confusing, but essentially it's looking back at whether or not your milestone inspection report will be considered to comply with Florida statutes. Mixed use and condominiums, when we have commercial condominiums, the responsibility for arranging the milestone inspection report lies with both the condo association and any owner of the portion of the building not subject to the condominium association or co-op form of ownership. So that is relating to the mixed use condominium and co-ops. It's basically condominiums. You're not going to find any mixed use co-ops out there. Both the association and the non-condominium owner are responsible for ensuring compliance with the milestone inspection report. So just because that you have a mixed use doesn't necessarily mean that you are not subject for those areas of your condo that are the mixed use pieces to not comply with your milestone inspection. The association is responsible for covering all costs associated with the milestone inspection related to that portion of the building that the association is responsible for maintaining. That again is in this glitch bill, and it was intended to address the mixed use and condominium hotels. Keep in mind the milestone inspection, there is an exemption. It does not apply to single family, 2-family, or 3-family dwellings with 3 or fewer habitable stories above ground. So that is the demarcation with the exemption to the milestone inspection. So we do have condos out there that are actually single family units or 2-family or 3-family dwellings, townhouse style condos. It does not apply to those particular condominiums or condominiums that are 1-story or 2-story. Once a local law enforcement agency determines that you're required to have a milestone inspection, written notice is sent to the association and with certified mail, and that's governmental notice for phase 1 of your milestone inspection. So I mentioned earlier that most of my clients that are going to be required to submit that have already received their milestone inspection notice from their jurisdiction. Curiously enough, I have seen many of those not be sent certified mail, but this was in the glitch bill, and some of those notices that were sent previous to the glitch bill passage. Following receipt, the association is going to notify the owners about the milestone inspection within 14 days and provide the deadline for completing the inspection. Keep this in mind. This is 14 days after you receive that milestone inspection notice. You're going to be sending that to the owners. Phase 1 of the milestone inspection must be concluded within 180 days after you receive the written notice. So this is where our local jurisdictions are coming into the implementation of the milestone inspections. Those notices will come. They will go to your registered agent. So hopefully you have an attorney or other responsible party to receive those. I have had clients call me and say we received another notice that we did not respond to our local jurisdiction, and that's because the management or the agent put that in a file drawer and did not do anything with that notice. So not the position that you want to be in. Phase 2, I talked about phase 1 milestone inspection being a visual inspection. If a phase 2 inspection is necessary, it's going to be your engineer or architect advising the association that a phase 2 is necessary. You have 180 days after the phase 1 to conduct the phase 2 inspection and to provide a progress report to, again, your local jurisdiction. The report should include a timeline for the completion of phase 2. And again, that is all glitch bill language from the May effective upon signing 2023 legislation. Post-inspection requirements. Upon completing both the phase 1 and phase 2, the architect or engineer who conducted the inspections will submit a sealed copy of the inspection report to the association and must provide a separate summary of the significant findings. And the submission will be made to any other owner who owns a portion of the building not governed by the condo form of ownership. Again, that is back to your mixed use condos. Within 45 days after receiving that inspection report, the association is going to distribute the summary of the inspection report to the owners. Does not matter if that inspection report has certain findings that may create some controversy or not. You have to submit that to the owners. It's going to be done through US mail or personal delivery to the owner's mailing address. Owners, if they've consented to receive electronic email notices, you can send it that way. The association also must post a copy of the report in a conspicuous location on the property and publish the report on the website if you are required to have that website. Keep in mind, we have a Palm Beach County sign here, but I'm sure there's others that are not in Palm Beach County sign. You are going to have county commissioners or your municipal bodies. They have the authority to pass an ordinance for condos and co-ops regarding some milestone inspection reporting requirements similar to your local jurisdictions. We may have county jurisdictions and also ordinances which, when repairs for substantial deterioration need to take place. So those types of ordinances pursuant to the statute may be passed by a county or other governing bodies. Again, we talked about ordinances with respect to your local jurisdictions. Be on the lookout for that. Most of the condos that we represent have local governmental ordinances that have been passed. Yes.
Paula, the report is 70 pages long. So do they have to send the entire report to them? Can they do it some other way?
So even though it may be an expensive mailing, you do have to send that report to your owners. If your report is 70 pages long and you have done your housekeeping work to make sure that you can send notices electronically, again, electronic notice is via email or facsimile, and it is a notice requirement that the owners have consented in writing to receive. It is a money saver over and over and over again. So if you haven't done that yet, this is again another reason why you may want to have your owners consent in writing to receiving electronic notices. Otherwise, yes, you must send the full report via mail. So that will be a cost, especially if you're a larger association. Repairs. Your governmental ordinances may provide that repairs must begin no later than 365 days after receiving the report. If an owner fails to provide proof of the repairs, owner being if the association provides proof of the repairs, the government, the local jurisdiction will review the situation and determine if the building is safe for occupancy. So now what we're doing is going back again to the Surfside tragedy. We're putting the responsibility on the association to obtain the reports. Your engineers are involved, your architects are involved. Everyone is around your building. And a year later, if you still have not made those repairs, then the local government jurisdiction can inspect and determine if your building is safe for occupancy. Keep in mind, the local jurisdiction at any point in time has the ability to come to your condominium building and inspect and determine if there are dangerous situations which require the building to be determined unsafe for occupancy. Typically, this comes up a couple different ways. You may have an emergency event where your local fire department has to enter to respond to a call. When they enter those buildings, and Katie has experience with this as a property manager from years gone by, where they notice that you are in violation of the fire code for some reason or another. Similarly, most of the time when clients are called into code enforcement for a condition of the condominium building, it's because an owner has called to complain about an issue. So nonetheless, if the jurisdiction does not receive that report and the repairs have not begun, your local jurisdiction can deem your building unsafe. Or without even deeming your building unsafe, you will be turned over to code enforcement for code violations. And then you will spend money on an attorney representing the association in front of those code violation hearings. So overall, let's keep our buildings in a condition where we're not subject to code violations. And of course, we're all safe and our buildings are in good condition. milestone inspection or inspection that's been conducted within the past 5 years that meets the requirements can be used instead of the visual inspection report. So the devil's in the details here, guys, and it's section 718.112. It also applies to co-ops, but there are a lot of exceptions that when you get into the requirements of a milestone inspection, you may have an exception if you've received a recent particular report. Can that be used or not? You'll need to go back to the specific statute to determine whether or not it can be. The Florida Building Commission is going to establish rules and building safety program by December 31st, 2024. Again, this glitch bill attempted to fill in the blank spaces with respect to how the statute from 2022 would actually be carried out. And the glitch bill essentially put in programs and inspection criteria from the Florida Building Commission to promulgate rules for those standardized forms for inspection. Because remember, in 2022, the question was, well, what does the milestone inspection include? We have no forms. Where are we going with this? These types of glitch bills were intended to help the different departments and divisions to make sure that they can come up with the rules for the milestone inspection studies and what they are required to actually contain. 718, alternative funding method. This is really interesting, and we'll get into CSRS in a moment. But this is the funding for the capital expenditures and the deferred maintenance of a multi-condo association that includes at least 25 condominium buildings. It's 25 condominiums. So keep in mind when we talk about multi-condominiums, that is, you have one association, but that one association entity governs 25 or more condominium buildings, condominiums. So with respect to reserve funding obligations pursuant to the new change in the statute, there are different alternative funding methods. What does that mean? It means it's going to be approved by the division to have an alternative for the funding method of the reserves. I really believe this was intended to address a lot of our multi-condominiums that serve 55 and older associations. And the division in the future will determine what that means to be an alternative funding method. So now we're moving on from milestone inspections. Takeaway point for milestone inspections. There's a phase 1, it's a visual, it's an architect or engineer. The glitch bill did provide that it can be another person who works with the architect or engineer, but at the end of the day, the architect or engineer is signing off and sealing on that milestone inspection phase 1, visual inspection. If your visual inspection has created concerns or issues, you're going to a phase 2. Phase 2 milestone inspection involves some destructive testing. You're essentially going to come out of phase 2 with a report that says these are the items that you need to do within a year to correct the deficiencies in your structural integrity of your building, essentially. The glitch bill moved to change some dates and timelines for your milestone inspection. If you are 3 stories or less, you are not required to have a milestone inspection. It's actually 3 stories of 2 stories habitable. So it's 2 stories habitable, not 3 stories. And then if you're a single family townhome, et cetera, you have an exception to that. So that is your milestone piece. And the glitch bill, again, changed some timeframes around, but essentially was intended to clarify and fill in some missing blanks. Nothing more substantial than that change from 2022 to 2023 for our milestone inspections. Then we talk about the Structural Integrity Reserve Study. We refer to that as CSRS, the acronym SIRS, CSRS. The term has been updated to mean a study conducted to determine the necessary reserve funds for future major repairs and replacements of the condo property. Let's keep in mind one of the reasons that the Surfside tragedy occurred and happened is because they were underfunded in their reserves. And that basically created a very big snowball effect for their funding to be able to fix the issues that they needed to fix from time to time and ongoing. The CSRS with respect to 718.112, it also applies to our co-ops.
Paula, just really quickly, for all of these deadlines, will they be making any exceptions for the properties that are still trying to recover from the Hurricane Ian?
The glitch bill, and here's again kind of the takeaway point. The glitch bill did allow a deference to your local jurisdiction for hardship. A hardship example for Hurricane Ian is a perfect example for your milestone requirements. So instead of, I think, pushing the time frame back and knowing that because that question had to have been asked at the legislative level. What are we going to do with respect to
And any properties
right.
that hit.
Remember the fire safety, life safety systems that was pushed back how many years? 8,
Like
9,
10.
10. I don't think the legislators wanted to be in that position with the Surfside tragedy. So I think what they did is they did defer and they allowed some deference to your local jurisdiction to push the milestone inspection back on a case-by-case basis by showing hardship. So work with your local jurisdiction if you are one of those condos, if you're subject to Hurricane Ian, if you have received your milestone inspection notice from your local jurisdiction and you are in line with your professional architect or engineer, respond back to that local jurisdiction, show them that you have the contract to perform it, and an email or correspondence from the company or firm indicating that you are set to go in March of next year, so that you're showing that there's a hardship because you as an association can't obtain the architect or engineer quick enough to perform your milestone inspection with whatever due date may exist. Again, for the Hurricane Ian issues, that also would be going to your local jurisdiction at this point in time. In the future, if they push that back or they make special provisions, hopefully, we're right now in the last month, thank God, of hurricane season, right? So we don't have that issue coming up, hopefully, for this year. But ultimately, if you are an Ian condo, then you're going to, at this point in time, work with your local jurisdiction. If something changes, we of course will let you know, but I don't see the legislature pushing those timeframes back like they did the life safety system example. Official records for 718, clarifying that 2 individuals may inspect records at the same time. These types of issues come up for your official records inspection request. That is an authorized person as a representative can inspect on behalf of that owner, and also 2 individuals may inspect at the same time. If you get to the point where you're arguing with an owner about 2 owners inspecting at the same time or who can inspect, I hope you're already at your legal counsel's desk, because official records inspections should come quite easily. It should be organized, and it shouldn't be a difficult issue to understand that 2 people can inspect at the same time if they are members of the association or an authorized representative. Reserves, the budget adopted by the association, who's obligated to obtain a SIR study, must maintain reserves for the items identified in paragraph G of section 718. I will go through what those are in just a moment. The reserve amount for these items will be based upon the SIR study. And items with an estimated remaining useful life that exceeds 25 years, or where we cannot readily ascertain what that estimate may be, is not required to reserve the replacement cost. This issue came up, for example, in the original 2022 Surfside legislation. They included a reserve item for, did they call it foundation?
Oh, foundation.
Foundation. So common sense will tell anyone, and you don't have to be an engineer or a community association attorney or an architect to understand that if your foundation has a useful life, then your entire building is based upon that foundation, right? So they took that particular language out, and then also recognized that certain items of a structure of a building do not fit into the formula for reserves of a useful life and then replacement costs, right? So that's the formula that we don't generally use it. It's required by law. That is the reserve formula. But when we're talking about the structure of a building, the glitch bill recognized and took back out the 25 years of a useful life, right? So we don't have to reserve for those particular replacement costs. It doesn't fit into the reserve formula. And again, typically foundation as an example, we won't be reserving for those particular items under that formula. But keep in mind, and as Katie knows in her experience, foundations do have problems from time to time. Your tie rods can pop and break. for your mid-rise to high-rise condos. Your foundation does and form the structure for your condominium, and things can go wrong from time to time, depending on how that structure was built. I think we just had a condo just the other day where one of the tie rods popped through the parking lot, where they had to do substantial work on that. So keep that in mind. The association, the reserve amount of deferred maintenance expenses is going to be structural integrity service study for such items. The association can adjust replacement reserve assessments annually to account for inflation. That is something that did not exist previously. So now, in addition to our formula, in accordance with 718, the change, we can account for inflation, which is super important because we don't live in a static world, especially with inflation on the reserves components and what they will cost 20 years from now when replacement's required.
Paula, I know I had asked you before when you were still talking about the inspections, but I have multiple questions. So on the budgets that are approved in 2024 before the deadline, which are 2025 budgets, do they have to be at 100% funding?
Okay. So let's kind of jump right into that because I know.
You have multiple, the same.
Okay. Let me just kind of. Pardon me, I'm jumping ahead, but let me answer the question. So the question that comes up frequently is this. For these reserve categories in subsection G, and that's what we're talking about, okay? The roof A through H. We have those reserve categories which must be, air quotes, fully funded by the December 31st, 2024 created budget. You are required to create and adopt your budget 14 days prior to the close of your fiscal year. Most of our listeners have a fiscal year January to December 31st. So you will be adopting your 2025 budget by the first week of December. Hopefully you're not going to wait or before, right? We're not, but a lot of you guys listening won't, but you know, first week of December, let's shoot for at least that date. So that will be a budget for 2025 adopted prior to December 31st, 2024. Therefore, your components that are required to be fully funded in any budget adopted after December 31st, 2024 is not required to be fully funded. So when we're talking about fully funding of these reserve categories, we're talking 2026 budget, unless you drive yourself crazy and something happens to your budget meeting and you adopt your budget late.
Get it done early.
You adopt your budget late, and now you are in, you know, a bad situation for A, adopting your budget late, because that's a violation of the Florida Administrative Code. And now B, you've adopted your budget and you are subject to fully fund these reserve categories. Another question we get often, I bet you have it in your queue, Katie, is what does fully funding mean? Does that mean you have to take every reserve category component and fully fund it as if it had zero life remaining and you have to replace all these tomorrow? The answer is no. The reserve funding formula is each component has a useful life, and then you consider upon the expiration of that useful life, a full replacement of that component. And within that, you're also talking about any substantial maintenance of that component as well to be reserved for. So that is in 2026, you will be looking at your SIRS, your structural integrity reserve study. It will show as part of the SIRS the formula for each component that's listed here to be fully funded. So for that year, you're going to take that particular formula. It's going to give a number. That particular dollar amount is what you will be fully funding for. You will not be fully funding in that 1 year for the entirety of the replacement cost for every component. It is spread out over a number of years. If you replaced your roof last year, you have a useful life of probably 20 plus years, depending on the roof style of a roof. So now you have 19 plus more years of a useful life. Your reserve amount for that roof is going to be much lower then if your useful life for your roof last year is 0 years and you still haven't replaced it, clearly you're going to have a much larger funding amount for that roof. That example applies to every component in your reserve. So A through H for these reserve categories are the reserve categories that have been determined by law, statute, to be the requirements in 2026 to fully fund pursuant to the formula. And they are roof, structure, bearing walls, fireproofing and fire protection systems. Very important there, because remember, and I always hate to bring it up, but the Surfside tragedy, a portion of what occurred, or part of the tragedy that occurred, is because their fire system failed those owners. And they did not, and I think
They would have had 7 more minutes.
they would have had 7 more minutes to get out of that building. So it kind of gives me chills just to think about. So very important, your fire protection, fire systems as part of the components that we're going to make sure that work. Plumbing, electrical systems, waterproofing, exterior painting. I always like to drive this one home a little bit. Waterproofing is a structural component because, and exterior painting is because it protects your building. They have some amazing paints out today that even offer more protection. It is an item that the board should speak to an expert, make sure that you understand the importance of that. Windows and exterior doors, keep in mind that in other sections of the glitch bill, the windows and exterior doors, if it is an owner component that is maintained by the owners, it's an exception to this. Any other item that has a deferred replacement cost of $10,000 or more, which isn't much in today's world, which would, and here's the takeaway, negatively affect the items listed above. So we're talking structure and fire safety systems overall. The SIRS study is going to identify, again, it is the Structural Integrity Reserve Study. It's going to tell the board exactly for those components, the formula across time that needs to be fully funded each particular calendar year. Owners will no longer be able to waive the components in the SIRS study.
And Paula, for the other items, the paving, the pool resurfacing, the things that are not structural, are they still able to waive and partially fund those?
They are. And the amazing glitch bill, I say that facetiously. The question is, the components we just reviewed, we can no longer waive. There are components in our reserves that still can be waived. Paving, your pool pump, other different items that, again, do not relate to structure or life safety. Yes, we still can waive or partially fund those, and that may be an important part of your budget planning process because it's going to reduce the increase that's going to hit the condominium owners in 2026. However, what changed this year is in the past, waiver or partially funding reserves was a majority of the owners voting in favor at a meeting at which a quorum was attained. Now it's a majority of owners. So you have to get a majority of owners. If you have 200 owners, you will be getting 101 votes to waive or partially fund those components that are not part of the SIRS components. So they've created, I think, a little bit of an extra hardship that didn't have to exist, at least this next year in 2026. So we're going to make sure that the owners understand that when we send our proxies out, we're going to send those proxies out with a piece of paper that is hot pink or a bright color to say, if you do not vote and you don't return this vote, then we will not be attaining the 51%, the majority of all owners. I talked about, by the way, the floor and foundation. Line items for 25 years or greater, we spoke about that. So I'm going to move through that. Again, the SIRS is going to be, it may recommend reserves are not necessary. The useful replacement cost can't be determined. That's going to be an exception. This is all part of the glitch bill where the legislation recognized that those items cannot technically be reserved for. Buildings that are less than 3 stories in height. Portions of components not under the condominium form of ownership. That's when you're consulting the legal counsel to make sure that you understand what that means. portions of components of a building maintained by another party other than the association. So you do have some exceptions here. It's probably not really applicable to most listeners, single family, 2-family, or 3-family dwellings. As far as the deadlines for the SERS, associations that existed before July 1st, 2022, unit owner controlled, must be completed by December 31st for each building. If an association is required to complete before December 31st, 2026, they may conduct the structural integrity reserve study simultaneously with the milestone inspection. What I'm seeing here is for the SERS and the milestone, typically a lot of my clients are using the same firm to perform both of those with each other.
Paula, I have a couple of good questions
Yes.
here. So one of them is the 2-story condos. Do they have any requirement for a reserve study at all?
So for a 2-story condominium, no, you do not.
It's definitely recommended.
But
You still have
for,
to replace.
well, so keep in mind, we're talking about SERS. So SERS is the mandatory statutory required reserve study. And it goes to specifically those items that can no longer be waived or partially funded. For our 2-story condominiums, 2 habitable story condominiums, you are not subject to a SERS. But in my early years of my condo HOA practice, 718 required a structural integrity study. Pardon me, it required a reserve study. A reserve study is performed under a specific reserve analysis for any component that you must statutorily reserve for. That was required every 3 to 5 years. They took that out of the statute probably 12 years ago, at least, I think. And they didn't put it back in. So for our 2 stories, for our 1 stories, for our single families that have a lot of, facilities or components for your condo, we always recommend a reserve study. Even for our HOA listeners who are still paying attention to this particular slide, we recommend, especially if you have a lot of facilities, a reserve study. A reserve study for our volunteer board members, which all of you are. You should rely upon expert opinions when you need to. A reserve study is not that expensive. And it shows, and you rely upon it to form your budget.
And I will just say that post-pandemic prices are very much different than the ones pre-pandemic. So even if you had a reserve study done in 2018 or 2019, your pricing is not correct. So you should have those updated if you had a reserve study done prior to the pandemic, because inflation is real and it's gone crazy. And the pricing, we're seeing roof that had, roof pricing, double from 2018.
Right. Well, so even from 2020. And I'm smiling because Katie just said inflation is real. And I feel like that should be a bumper sticker or a t-shirt, right? Inflation is real. In the past, reserve studies and your standards for reserve studies in Florida did not include an inflation component. And even if it did include an inflation component, nobody can ever anticipate or predict an inflation. So if you had a pre-reserve study from 2020 or even further, again, the recommendation is every 3 to 5 years, whether you're a co-op, condo, or HOA, for those components that you need to reserve for.
And I have 2 good questions here that both are kind of the same. So does this bill address on how to distribute the existing reserve funds into the traditional and reserve, number 1, and number 2, are we going to have 2 sets of reserves for the structural and non-structural going forward?
Okay, so that is an amazing question. No, this particular bill did not address that. And so that's why I kind of laugh when I say it's a glitch bill, because now we just need a glitch bill for the glitch bill overall. There are so many pieces to this, both from an accounting perspective on whether you have pooled reserves currently as a condo or co-op. And then now we have to move to a non-wave component under subsection G. And then we also have our components that still can be pooled, because those are the components that we can, that are not related to structure or life safety. There are there's analysis going back and forth, and Katie is abreast. Katie is also a president-elect of Community Association Institute, which is a national chapter for our local chapter. So there's a national conversation going on overall with reserve studies, but to specifically our Florida, the issue is this: we have now our reserves that exist prior to our requirements to meet SERS for the components, life safety, structure components. And then also we have our subsection of non-life safety structure components that we can still pool and we can still potentially waive. For all of that, what do we do with our reserves that are currently pooled? Can we move those into now the existing reserve, moving forward for our life safety and structural components? Speak to your accountant. They are moving back. I say they collectively as an industry, they have addressed that we may be able to keep some pooled and then start anew. Can we unpool them? And if we unpool them, do we have to have an owner vote? All of those questions still are unanswered. That's kind of the best way to describe it. It's still really unanswered, but the best resource for your board is going to be your accountant, CPA, to address those questions, because they're going to let you know whether you can move them in, move them out, what makes sense based upon your current funding anyway. I am the impression that you can move pursuant to the requirements. The pooled accounts allow you to use those reserve components for other components as they are required to be used. So I believe there's going to be a blending for the pooled into now the non-waivable amounts. That's really how it should work, because at the end of the day, whether it's SERS or prior to SERS requirements, you are funding those components pursuant to its formula for each component. So again, refer back to your CPA or accountant for that. But ultimately, I believe you'll be able to, again, you're going to do your analysis on your roof pursuant to your current roof reserve, even if it's in a pooled account. But whether or not you'll be able to in the future use that particular reserve amount in a pooled account, this is still unanswered for the accounting portion of the accounting part of it. Individuals who may perform structural integrity reserve studies. Again, this was decreased in a sense to provide that it may be performed by a person who is working under the architect or engineer. This is to address, this was in the glitch bill, to address the fact that we do not have enough engineers or architects to perform all of these SERS studies for our condominium associations. Waiving or reducing reserves. Again, I just mentioned that we talked about the December 31st deadline, so we've covered this. You are going to adopt your December 2025, pardon me, you're going to adopt your 2025 budget prior to this date. If you don't, you will be stuck with your fully funded reserve for items listed in G. Alternate use of reserve funds. Reserve funds and any interest must remain in the reserve accounts, can only be used unless approved in advance by a majority of all voting interests. For budgets adopted after 2024, members of the unit owner controlled association must obtain a structural integrity reserve study, and you cannot use those funds for any other purpose other than the replacement cost of that component listed in G.
And I just actually attended a panel with Nicole from Hafer and Company.
Right.
And she actually did recommend keeping the two separate sets of reserves because your interest in everything is still fluid in the non-structural items. It's not in the structural items. They can't be used for any other purpose.
Correct.
So she said it's probably better to keep two separate sets of reserves or have them separated on your reserve schedule as the structural and non-structural, because
Agreed.
you have more options for the non-structural stuff.
Right. So that almost goes without saying,
Yeah.
right? You're going to keep these two categories separate because you have the ability to use your reserve funds for those non-structural life safety to the same degree that you were able to in the past prior to these bills. And on the other hand, for the structural life safety, we have the statutory requirements with respect to, obviously you cannot waive those anymore. So you're going to keep those in a different category, but those are really good questions. Again, I know Hafer and Company is on today, and if he wants to chime in on any of this, I'm more than happy to have him do that too, on how they're handling that. We're going to move through the developer created SERS, Katie, slides on this. In
We're
addition,
gonna send those to you. If you have
Right.
any extra questions, just email them so that we can conserve
Right.
time.
if
Yeah.
you are an association, condo association, co-op, well, you're never going to be a co-op association with a developer, but if you're a condo association with a developer, And you're gonna be facing
Email us, we have a
turnover.
developer checklist.
We do,
and
we
we'd
have
be
all of
happy
that,
to
but
talk
this
to
we're
you.
moving through because these are developer controlled associations. Dispute, as we know that 718, 719, and 720, this only applies to 718 and 719 at this point. The dispute under the prerequisite to filing suit now includes information and details on the structural integrity reserve study. It is considered a dispute. Katie is waiting for me to make my bad joke about the red guy yelling at the blue guy, and I'm not going to make that joke because it doesn't even make sense anymore here. This is my favorite slide, just to let you guys know. Disputes continued. Again, those disputes, they are mandatory non-binding arbitration. They are not subject to that. They must be submitted to pre-suit mediation. So that section has changed. Maintenance of common elements. Of course, it's the responsibility of the association, unless it's specifically assigned to the unit owner. The association is required to provide the maintenance, repair, replacement, as stated in your declaration. Upon turnover, we have new protocols, license our engineer, structural integrity reserve study. These again relate to turnover. Turnover inspection report, very similar to a SERS. That is if you are a developer controlled association at this point in time. Developer disclosures, purchase and sales agreement. That's a good question. The purchase and sale agreement must contain a clause allowing the buyer to void the agreement. Non-compliant contracts can be voided. That's nothing new with respect to 718, but you will have owner disclosure requirements. This is in the original bill from 2022. We are going to provide those prospective owners with copies of your milestone inspection and your structural integrity reserve study. Consult legal counsel if you are in a purchase or sale agreement and you don't, and your association does not have those done by the date in the statute that's required.
Paula, this is a great time to ask this question, came up earlier. What about when the lender sends over their questionnaire and asking for the report?
I love that question. Okay, I like that question a lot because those questionnaires that are sent by Fannie Mae or other underwriting lenders is because Fannie Mae does, and as of January 1st, 2022, I believe, yes, 2022, their underwriting requirements changed. And with that change, their underwriting includes a questionnaire that is sent to our condo managers, co-op. It's condo because you're not getting mortgage co-op anyway, but it's condominium associations, and they have the questionnaires that have trick questions, I like to call them, indicating, do you have any structural issues that or any reports, etc. The questionnaires are not required by law to be completed and returned. However, we all know that if you don't return and complete that, then that particular individual is not getting a mortgage on that particular property. So Florida statute does provide that those questionnaires can be, you can charge your attorney's fees related to filling those out. So my recommendation, about 90% of the questions are fine to answer. You will find about 6 questions that relate to the structural reserve study or questions regarding the structure itself. Do you have any work currently being performed on the building that relates to the structural integrity, safety, occupancy, etc.? So refer those to your attorney so that they can assist the association to return those. And again, some of those, if you have already put in the protocol to respond to those, you can charge the attorney's fees or other costs related to filling out that particular questionnaire. For our managers who are listening today, oftentimes your management company has its own internal protocols with respect to responding to those, but keep in mind, in my opinion, that's the association's response. So make sure that you work with your board to understand how you'll be filling those out and returning those, but definitely refer to your legal counsel on those particular questionnaires that you see, because they can and they do include, I call them trick questions, but they're just not worded very well. So if you're honest on that and you're saying, yes, we have our catwalks that are currently being an ongoing concrete restoration project, what have you, then sometimes that triggers the underwriting to question it. And I have seen, for example, where the underwriting won't move through because the answer to a questionnaire. So best practice is to refer to legal counsel for that. House Bill 437 adds Patriot Day, September 11th, to the list of days when we as condo owners may display armed forces flags. House Bill 1575, effective July 1st, 2023. This is interesting, and it has not been well reported in a sense. Radio strength for fire department communications. We have certain areas of our condominium buildings that have poor coverage. So we will be required to make sure that the life safety systems include connections that the firefighters have the radio strength in our building. So you will have studies performed. The two-way radio communication enhancement systems may be included in that, but that will be based upon a study. And you will see from your vendors information to make sure that you are compliant by January 1st, 2025. So that's essentially a little more than a year away, where existing high-rise buildings are not required to comply with that enhancement system until January 1st, 2025. So that's January 1st, 2025. You are going to be required to make sure you are compliant with that two-way minimum radio strength for high-rise buildings.
And that's buildings with more than 75 feet. So however many floors that equates to, you need to take the measurement. It's usually between 3 and 4.
Sort of, but this
Yeah.
is what I also like. It's 75 feet above the lowest level of fire department vehicle access.
Oh,
So when we
okay.
talk about that, that's still the same that we talked about with the life safety systems and whether you're required to have a life safety system because you're 75 feet above the lowest level of fire department vehicle access. That means when I am on my fire ladder, I have 75 feet from my fire ladder to the lowest threshold of an accessible floor. Okay. If I have, if my condo building is set off 25 feet from the perimeter of the curb where the fire truck pulls up, I may not be 75 feet above the lowest level of threshold. I may be more than 125 feet because the ladder doesn't extend that far over the grass. Okay, so I just want everyone to understand it's not a linear 75 feet, take your tape measure out and go up. It's essentially, imagine yourself on the ladder, and that's the 75 feet from the lowest threshold of where you can access that particular opening, whether it's a window or a door or even a patio, exterior patio, catwalk. It's 75 feet from that point. That is something, again, as a board, you are going to rely upon your experts to tell you what to do here. Section 440-103, every employer as a condition to receiving a building permit is going to proof and certify to the permit issuer it has secured compensation for employees under this chapter. This is going to be, again, evidenced by certificate or exemption. These building permits, really, this is just, again, this is relating to your contractors, but make sure that if you enter into an agreement or contract for a contractor, they are going to be issued building permits consistent with this statute section. SB 2A, the reinsurance in Florida is, it's already passed. In effect, in Florida, insurance companies have the option to purchase reinsurance at reasonable market rates. This is done to prevent additional increases in premiums. This was the bill that in May was intended to be solely related to insurance. We have timeline reductions. The deadline for filing a newly reopened claim is reduced from 2 years to 1 year. And for a supplemental claim, it's reduced to from 3 years to 18 months. The takeaway point here is this: when you sustain damage as a result of an insurable event, as a board of directors, you need to timely report the claim and you need to timely process that claim through the proper adjustment. If you do not, you will be subjecting your association to being foreclosed out of receiving your insurance funds because you have not met the deadlines. Those deadlines have been shortened. Insurance companies now have 90 days to pay or deny claims. The time for insurance companies to review and acknowledge a claim is reduced from 14 days to 7 days. So now we're putting the onus back on the insurance companies to acknowledge those claims. Insurance companies must now begin their investigation of a claim within 7 days instead of 14 days. The period for insurance companies to conduct a physical inspection, including your hurricane claims, is reduced from 45 days to 30 days. So again, going back and forth through our insurance contracts, the association has a shorter time frame to report and to make sure that their claim is timely filed and properly filed, because the time to do so and do so properly is reduced. Insurance companies have a reduced time to come out and investigate and communicate regarding the claim. Insurance companies are required to send the policyholder any adjuster report damage, estimating the damage. Undisputed benefits had to be paid out within 90 days, but now the time frame is reduced to 60 days. These changes became effective on March 1st of this last year. Attorney's fees awards. This is important because this will eventually, years down the road, change, hopefully affect our market. The provision related to one-way attorney's fees in property insured claims have been eliminated. In the past, if you sued your insurance company for breach of the policy and for bad faith, it was a one-way attorney's fees. So if your insurance company prevailed, they still could not seek fees from that particular plaintiff. That has changed. So now you will see your attorneys that represent individual plaintiffs change their filings and change their representation, meaning that if they don't feel like they have a very strong claim, they're not going to bring it. This means that neither party is awarded prevailing party attorney's fees. Each party is responsible for their own fees. However, this is mitigated, again, if an offer's judgment is made. That's really getting into the nitty-gritty about representation. So offers of judgment, your legal counsel will know what that means. And again, offers of judgment mean where you understand and know you have a very strong case. So hopefully the intent of this legislation was to reduce nuisance type claims for attorney's fees, for insurance claims. Assignment of benefits under residential and commercial property insurance policies issued after January 1st, post-loss insurance benefits cannot be assigned to a third party. This means that no assignment of benefits is no longer an option. You're not going to be assigning those benefits to a public adjuster type of company or to a contractor who says they're going to come in and remediate and do all the work for you. Just assign those benefits to me. That is no longer allowable in Florida. Assignments of benefits, again, we can sue a property insurance company for bad faith based upon a claim settlement. However, we must first prevail in the breach of contract claim. In the past, we could sue you for breach of contract and for bad faith against the insurance company. We can no longer do that. Receiving an appraisal award higher than the insurance company's appraiser's final estimate may be considered evidence of bad faith, but on its own does not give rise to a bad faith claim. So in the past, if we received an appraisal adjustment higher than the insurance adjustment, we had a bad faith, arguable bad faith case. No longer the case. Flood insurance, we took this out. If you had citizens, you were required to obtain flood insurance. That's no longer the case as well. Mandatory arbitration.
It's still recommended because rising water is
Listen,
not covered under your regular policy.
We have a good insurance course as well. If you have a wind policy, if you have an insurance policy and you've never had to learn the hard way, Katie's going to save you some time. She's going to tell you that to not have a flood policy is bad practice for your home, or otherwise, if you are a condo, you'll have a flood policy. I don't ever recommend trying to determine whether or not you are in a flood zone to determine if you need a flood policy. Over half of the flood damages relate to property that are not even in the flood zone. This is talking about just rainwater, especially in Florida, depending on where you are, up and down our peninsula. You may have a flood by virtue of the drainage not effectively getting that amount of rainwater off of the surface of the land. So flood policies are highly recommended, even if it's a flood that's related to a hurricane that may not be covered by wind. Again, don't learn the hard way. And flood policies are typically very affordable compared to our wind policies. Mandatory binding arbitration. This allows insurance companies with arbitration clauses to go through dispute resolution instead of litigation. These are just specific policy changes. Consult with your agent as to what that means to you, what that means to your HOA, what that means to your condo co-op. Senate Bill 252, COVID-19 related. Business entities, including not-for-profits, may not require a COVID-19 test. Hopefully we won't have to talk about this anymore. That's always been my advice anyway, even before this legislation. May not require a person to wear a face mask. This is a business. This is not a condo. We can talk about that if we ever have to talk about that again. Construction defect, keep this in mind. This is if you are a turnover condo or HOA client, then turnover from developer, you need to consult with legal counsel who specializes in turnover, because your statute of limitations was just lowered and it really does affect turnover claims against developers. However, if you are a person, whether you're condo, co-op, or HOA, and you have a construction company who is remodeling your unit or home, then you have a lower statute of limitations to refer that construction defect to a lawsuit once you know about the defect. So this is, again, statute of limitations, statute of repose. We won't get into what that means, but it's been reduced from 10 years to 7 years. So again, your timeliness on addressing a construction defect has been reduced. House Bill 949, golf cart. A golf cart may not be operated on public roads for a person who is under 18 years of age. Or if you're over 18 years of age, you can just have a valid form of government ID. Keep in mind when we use and we reference the word golf cart, there are 3 categories of golf cart. There is a golf cart that is less than 25 miles per hour, and that is intended only for your golf course. There is a golf cart that can go up to 25 miles per hour that is intended to be on a roadway or street. And then there is your licensed, insured golf cart that is the same as a operating vehicle like a car. So this statute section spells that out with respect to who can operate a golf cart when we have communities typically that are gated communities, and we have a lot of golf carts that go from house to house. But 949, there is a new law on that. It was actually effective July 1st, 2023.
And I know I've seen basically when I've driven to some of these communities, and even in my own area, the municipalities have posted signs warning people too that this is now law, and you know they will give them tickets.
We will expand this slide to provide further details because there's a lot of questions that aren't answered by this. Elevator accident reporting. This is important. If you have an elevator, you have 5 days to report to the DBPR an elevator accident. That includes Katie getting stuck in an elevator for just a few minutes and having a panic attack. Or it may include me getting stuck in an elevator for an hour and enjoying the quiet private time in the elevator for that hour. You have to report that within 5 working days. The form are available at DBPR. There's a license there, but if you have an elevator, just be aware any incident with an elevator stopping, in my opinion, would be an incident report required for that. House Bill 837. The law already in effect was supposed to reduce frivolous claims against associations and lower liability rates. This is House Bill 837. This legislation outlines community associations are exempt if a third party commits a crime on their property. This is applicable to all multifamily residential, townhomes, apartments, condos, 5 dwellings or more. House Bill 837 creates a presumption with respect to that crime exemption, and that will include the association maintaining and verifying that you have the following components: security cameras, lighted parking, deadbolts measuring, locking devices, lock gates, peepholes or viewers on doors. So again, all of these items create a presumption that you have met the requirements, that if a crime occurs, the association will not be liable. So it's not a straight, we are no longer liable if a crime occurs. It is a presumption, if we have done these things, that the association is not liable. So that's the crime prevention through design study. It's going to verify that your association has done these things. It should be no longer, or it should be older than 3 years old. Again, the takeaway point is we can now create a presumption that if a crime occurs, the association is not liable. But you're not creating that presumption unless you've done this and you've met these requirements through a verified law enforcement agency. Will say that the study has met, that the association has complied. Okay. Couple different types of things to think about there, including we're going to provide our employees with safety and crime prevention. Training is going to familiarize our employees. So those are the steps you have to take to make sure that if, God forbid, something should occur, then we're going to have a presumption that it is not a situation where the association is liable if we've done these things.
And just so you know, we've talked now to 3 security companies. We had one at our event last night. The training for this, actually to do the inspection and the report, it's not even being made available until January.
You mentioned that.
So they made this legislation and the tools aren't even in place yet. So don't get all worried about it. Wait till after probably February, when people are getting their licensing to do the reports, to get yours done.
Right. It's one of those areas where you're going to hear from your vendors on this. And then when you do, make sure your board's informed that if first of all, you may already be doing all those things, right, Katie? Except for perhaps the training details.
Yeah.
But all of the different components with respect to your community association property may already be in place. And if that's the case, then you certainly want to take advantage of this and obtain the report that you have complied. If you're not one of those associations where you don't have all those components in place, then it's going to be a cost and expense to get those components in place. But the takeaway point here is now you know, and you know that it is now something that we can shift the presumption back to basically claim that the association is not liable because we have all done all those things. We have obtained a report. House bill, building construction. Bill makes various changes to review and issuance of building permits. We're not going to touch upon this too deeply. Again, when you're in the point, when you're a condo co-op or even an HOA association board, you're going to be meeting all of those requirements through your contract with your contractor.
And you want to have your attorney review the contract with the contractor and make sure that you have all these things, because that's our job.
That's our job. And I was just discussing with someone yesterday on a very expensive lawsuit from the association to the contractor. And my colleague Steve Brighton came in and said, "Are you kidding me? This is a $10,000 contract for a roof repair." And I said, "I know, but the contractor burnt the whole clubhouse down." So it goes to show that when we are working to now file the lawsuit against the contractor and we're looking at the contract and it's a 2-page proposal for $10,000 signed by the president, which should have actually went through the attorney for an addendum, et cetera, then we know that any contract, even if it seems minimal to the association board, please have your attorney prepare an addendum to get that contract at least to the point where if something bad should happen, we know that we have, again, required and met the requirements for this new House bill construction. That is your attorney's role for your board. Limitations of actions involving real estate appraisers. I hate to say this, but I don't even know why these are part of the slides.
The GDPR made us put that in.
Oh,
That
really?
came out in the update.
Okay,
Yeah.
good to know. Shows you what I know. That's Katie's job. Katie just informed me the DBPR, when we do these courses, requires certain components to be included. So I will hold back on my opinions. This is House Bill 213, limitations of actions involving real estate appraisers. Here we go. The bill creates a certain section for new and exclusive, again, statute of limitations and government actions against appraisers for your real estate.
We're going to send it. You can kind of speed through those because we're running out of time, Paula. So we can just skip through those. We're going to send them the perfect. They can read through it.
And you guys can read through that because I know you're dying to know all that information.
Really quickly, before you move forward, I
Yes.
had two good questions. So one was there any updates regarding the life safety systems? Was there any pushback? I know they had talked about in like March or April of, extending the deadline for that. Was there any extension on the emergency life safety system installation upgrades?
There was not.
No.
So nothing updated on that life safety system upgrade, but there was a lot of talk about it. And there were some bills that were introduced
but
and
they did-
proposed, but they did not go anywhere.
I think they won't anymore because of what happened at Surfside. I really do think they won't extend that anymore. And then
Right.
also, if
That's
you
a
have-
good point.
Yes.
So
if you
you're
have-
going kind of fast, but to the life safety system, because that's the kind of information that the listeners want to know, that will probably not be pushed back again. And that again is due to the Surfside failure of their life safety system.
And then secondly, back onto your property safety, but you don't have to skip back on the slides. If you have cameras, how long do you need to keep the video on file? Is it 30 days or?
There is no requirement to keep the video on file for any particular period of time. So it could be an hour, it could be 24 hours. I think, again, this is a common sense approach. Sometimes you're not going to know what occurred, whether it's a break-in or a crime, for probably up to even 48 hours. So based upon the circumstances of your association, I would say a reasonable amount of time. There is no specific legal requirement, but I would say at least, in my opinion, 48 to 72 hours, depending upon your data and your capacity to keep that. Videos are not official records of an association, by the way. So unless you're subpoenaed or you receive a letter that says do not destroy evidence from counsel, the videos are not official records because they're not in writing. So when you do receive a request for that, again, consult your attorney to determine how to respond to those types of requests. The bill, drone services, we're talking about, prohibits political subdivisions from withholding or enacting ordinances with respect to drone delivery services. This is our legislation just trying to get ahead of what's probably happening fairly quickly. Florida Building Code, again, exempts drone ports from the Florida Building Code, except for any stairwells. This is something, I'm just going to end on this, for drone delivery services. When we do amendments to our governing documents for use restrictions, we will often include restrictions regarding the use of recreational drones. So kind of a departure from what we're talking about here, but it happens often in our HOAs, especially with respect to people using recreational drones and creating nuisances for individuals in their private spaces like their backyard.
You just can't stop Amazon from delivering.
Correct. Which I don't think anyone wants to. We want Amazon. We just don't want the kid down the street scoping out the backyards and the pools, right?
Yes.
So that concludes our very extensive legal update.
And we know it is extensive, but like I said, the DBPR comes back with a list of criteria for things that sometimes are irrelevant that needs to be in the legal update when we submit it for approval.
And that is Katie just making me feel better about stuff I wanted to skip over very quickly. So we do appreciate you all attending. And if you have any questions, if they're general questions, we don't mind receiving those general type of questions, but we won't answer specific questions specific to your community association. So if you didn't have an opportunity to ask, or maybe you review these slides later on, feel free to reach out and we are happy to address general questions. We will let you know if they're not general enough.
And that's the end of the actual presentation. So you don't have to stay on, but I do have some questions that I'm going to give Paula that I've been holding on to in the chat. So you're welcome to stick around and listen to those answers. But if you need to go, you are free to go. The course is actually concluded. So the first question is, do the cameras, if you have cameras on your property, do they need man monitoring?
No, so cameras they do not need man monitoring. You don't need somebody behind the camera monitoring those systems. You want to make sure if you do implement, depending upon the service that you're willing to provide, you do want to potentially have an amendment to your declaration indicating that the security services, which has cameras, is not intended to be a foolproof system that's going to prevent all crimes to take place. So you'll see in a lot of developer documents that they have the bold language, which is trying to exempt them from liability. Even though we have a camera, that does not mean that the cameras are a system that will prevent crimes. But rather,
Awesome. Does the 75-foot, for the required stuff, for the life safety stuff, does that apply to, the high rises for the new radio frequency and the life safety systems?
mhm.
It's both.
So good question. The 75-foot rule, as we'll call it, again, it's not a linear 75-foot. Your experts will help you out to what that means. It is essentially 75 feet is the extension of a ladder on the back of your fire truck, meaning that a fireman can climb that ladder and get to the first threshold to your condo or co-op. But if your condo or co-op is located 25 feet off of the curbing where the fire truck would pull up, or even keep in mind where the fire truck has to pull up and have the water extended to that particular truck, all of those types of factors are going to come into play as to what 75 feet means to your condominium or co-op.
Going back to the distribution of the milestone report, would it be a good idea if they have a website that they put the actual report on the website and just mail everyone a copy of the link and say you can access the report here, as long as that is mailed to everyone?
So the statute does not provide for that. The statute provides if somebody wants to do an official records inspection, you can refer that person to your website if the official record is listed on that website. But for this particular statute section, it is a mailing or an email if they have consented to written email, electronic consent.
Okay, and then several people, can we still have pooled reserves even on the structural stuff?
Okay, so again, referring back to your CPA or your accountant, I don't believe that you will be able to, you have to still fully fund each component. So the fully funding will not be able to use a pooled accounting method to determine the funding for that. The pooled method worked when you were able to reduce or waive certain components at certain times or reduce overall. That's how a pooled method actually exists in a sense. Because we can no longer, the direct answer is this, you can no longer waive or partially fund for those components. So your straight line reserve formula for each of those components will apply. Whether or not you can use the pooled accounts that you have now and put those into your reserve line items for those components, you're still each time, even if you have pooled, you're still each year using your straight formula to determine what your fully funding will be for each component. Okay, and then you don't even get to that question because at the end of the day, you're fully funding. So it doesn't matter if you're pooled or not. Does that make sense?
Yes.
Okay, so essentially the question kind of resolves itself because you're fully funding, the pooled method of accounting really no longer applies to those particular components in G.
Yes. This I thought was a really good question. I thought I would ask you. So the milestone report is requiring repairs to the building, which is very old and has some things that are encased in terrazzo. We're going to have to change the flooring to do the repairs in the milestone, and we're not going to get 75% to do a material alteration.
That's my favorite question of the day.
I knew you'd like that.
We should have like, can we do, like, we used to do all of these types of webinar seminars
The
in
panels,
person,
yeah.
right? So then people would get to walk away with like a little, less than $25
Gift card.
We should figure out a way to do that because that's my favorite question so far. So the question goes like this: you have terrazzo floors, but your milestone inspection is going to go into destructive testing, and by way of that, your terrazzo floor is going to be damaged to the point you can't replace it. That would not be determined to be a material alteration for replacement. Material alteration is any palpable or perception change to the common elements. And if you do that, you have to have 75% approval of your owners to change that. However, there are exceptions to the material alteration, and those exceptions are varied based upon the facts and circumstances. But if you have to do destructive testing for the milestone and then replace that flooring with something else, because we know we're not being able to replace it with terrazzo flooring, then you will be able to replace it with another type of flooring without obtaining the 75%.
That made this lady very happy.
I love that. We're gonna have to find a way for Katie to send the $10 gift card to my favorite
Yeah, we'll
question.
have to do that. Your favorite question now? Okay.
Is that it? Yeah.
Did the condominium with buildings of 2 and 1 story, will they still have to have fully funded reserves as well?
Condominiums that are 1 and 2 story will not have to have fully funded reserves, even for the components listed in item G.
But the amount to waive is increased to a majority.
But the requirement of the owners to waive it is now increased to a majority of the entire membership, not just a majority at a meeting.
Awesome. And the last one, we'll take one more question. So if they are in Broward or Dade County and they still had the county requirements of the building recertification, do they have to still, if they've just done that, do they have to do that on top of it? Or has the counties now agreed to coincide with the statute?
So if you have before July 1st of 2022, I believe is the date of this glitch bill, refer back to your local jurisdiction. They'll be happy to answer your question for you, but that inspection report is going to carry you forward to meet the timeframes now. So that glitch bill did address for those Miami and Broward condos that had just attained their milestone inspections under those county ordinances, the ability to create that into the milestone pursuant to Florida statute.
And I was gonna say, and even if it didn't, you talk to the engineer and tell him to put it in a new format, right?
It depends. I don't know if an engineer would do that, but that's no longer necessary. Just work with your local jurisdiction and it will be able to tell you that that report is and will substantiate for your milestone.
And that's it. Please check your spam box for your certificates and remember 7 to 10 business days on your CE credits. And we hope you all have a great day. Thank you again for attending.
Thank you all. We really appreciate it. I did that.